School trials.
Yes, Mr. Reaper.
Right. I may or may not have completed my maths homework. This is, I think, where I've got to. In relation to the doctor return rate, one excludes the 3 who are on annual leave. So of the 22, 3 are on annual leave. You have returns from 16, and you have deemed returns from 2 because they're off sick. So, sorry.
Yes.
And that means that you've got 18 out of 19. Which gives you 94.74%.
Could you repeat that?
94.74. I'm sticking to the Trust's approach of 2 decimal places percent.
And for the
So then
validity exercise, the one who didn't bother is...
There are 3. So the first 2 on validity, there's the doctor return rate, then you've got the duty return rate.
Right.
And in a sense, we can't do this exercise because we don't know the duties. But let me put it in this way. We have got returns, and let's assume that they're full returns from each of the doctors.
Yes.
So sometimes they won't finish every duty they've worked. So assuming that you have full returns from the doctors who've submitted returns, you've got returns from the 9 who were compliant, the 7 who were part compliant. So you have returns from 16 of the 22 doctors.
Yes.
And that is 72.72%. If I'm right on that, that would mean that the round was invalid because you haven't got a sufficiently high duty return rate. Putting that to one side, you then have to consider compliance with natural breaks as one of the range of matters that's being monitored. In relation to those who are absent, the easiest way of doing it is you find out how many duties are not compliant. So of the 7 who've said some of our duties were not compliant, you work out how many are not compliant. And then you divide it by the number of expected duties in that period. And expected means those that were rostered to be worked in that period. And that would give you a percentage, and then it's the inverse of that.
Well, I should have introduced that elaboration. Let's say the 7 say half yes, half no.
Yeah.
So that's 3.5 doctors worth of compliance added to the 9 who were wholly compliant.
You've in effect, you've got 3.5 of non-compliance.
Yes.
So that I think is where I've got to. What I would ask is that I haven't been able to get sort of concluded instruction that is the correct approach. So what I would like, if I may, if I've got that wrong from the trust position, if I could just submit a single sheet which said what the trust correct position is. But that's my understanding of it.
You haven't enjoyed the full natural break.
I haven't. You're absolutely right.
Yes. Well, it was more than 30 minutes. Anyway, let's not go there. But now, but what about the people on leave and off sick?
Well, those people are deemed to be, well, effectively they're deemed to be compliant.
Yes.
Because you're looking at the expected rotas and you've expected that the annual leave will be there.
So, and the one who didn't bother is added in as well.
Yes.
So, I think on these figures then, it would be 18 and a half doctors worth, as it were, are compliant, 3.5 are non-compliant, so that the threshold is passed quite comfortably.
Yes. But if I'm right on the middle test, it wouldn't be a valid monitoring round, so you wouldn't get to it because you haven't got enough people submitting returns to mean that you're looking at what would be valid. And
the one who didn't bother, or who was too tired, or for whatever reason,
yeah.
On your case, can be taken into account at the compliance stage if one gets there, but can't be taken into account at the duty return stage.
I think, yes, that's right, because they haven't submitted return.
And in this case, her failure to put a return was absolutely crucial, because had she put one in, whether saying I took my breaks or I didn't, it would have got the duty return rate over 75%.
That looks right. That looks to be the case.
Thank you very much.
As I say, I hope that's right. It's my best understanding, and I will make sure that you're properly appraised of the trust position if I've got it
Yes.
wrong. Can I deal with, as I said, just a couple of final matters in relation to rationality? The first is this, that the Dr. Hallett's position is that it's illogical to strip out weekly days off, but not days of annual leave, when you're looking at compliance. We say, of course, that's not right. That's not a matter of irrationality, because the days off which are fixed in the rota are there. One knows that they're going to be taken off. They're featured and factored in to the construction of the rota, and they're there. Whereas annual leave is something which is factored in only as a matter of prospective cover. So you don't know exactly when it's going to take place, but you've adjusted the working times in order to anticipate that at certain points people will take annual leave. So it's an area where you've constructed the rota to take account of the possibility, whereas with days off you know when they're going to be. The second point is this about breadth of application. The test, as I've suggested it, is that one has to consider whether no rational NHS trust could have adopted this methodology. And what the court does know is that a very large number of trusts did adopt it. Now, it's a slightly forensic point, because it doesn't mean that lots of trusts can't be irrational. That is conceivable, but I do say it does make one stop. It makes it less likely that all of these trusts who've applied and used the same methodology through the software, it would be surprising if they have all adopted an approach which is irrational. As I say, it's a forensic point. It doesn't determine.
Jury point.
Yes, absolutely. It is, but it has some force for this very learned jury, because it would be surprising if it would be surprising if across the NHS a methodology had been adopted which was something which was wholly perverse, which is what we're looking at. The last and short, I assure you, point is the ground 7.
Yes.
And that's the specific challenge to
Yes.
monitoring round 2. This, as I think, has been accepted. It is an entirely discrete freestanding point. It depends upon the application of monitoring to a singular factual circumstance of one particular round. And if I may, can we start just with the factual findings that relate to it? And one can see that in the judgment at page 146, paragraphs 50 to 51. So, although there were, you see in 49 it introduces MR2 for general surgery F1 rota. Although there were 22 doctors assigned to this rota, there were only 21 who took part in the monitoring exercises. One of the doctors was retaking one of his seats and was limited in his working pattern to day shifts only. In other words, not participating fully in the rota as it was constructed. The system treated his doctor returns as unassigned for the purposes of establishing validity, and there was another doctor who produced...
I'm so sorry, you were ahead of me. Paragraph
50.
151, is it?
I'm sorry, it's page 146, paragraph 50.
Sorry. Right, yes. Thank you.
So that we've dealt with the doctor who's retaking a seat, so has a limited working pattern. There was another doctor who produced no returns within the exercise. Accordingly, the doctor return rate was calculated on the basis of 20 of 21 doctors engaging in the exercise and produced a return rate of over 95%, which was therefore valid. In terms of the duty return rate, the monitoring exercise report shows that there were 218 expected duties, calculated on the basis of 22 doctors, out of which 156 were monitored. The duty return rate was calculated, as you see, at 71 odd %. This didn't meet the duty return threshold of 75%, and the exercise was treated as not valid. Then at 53, after the maths behind it, in terms of the natural breaks exercise, the trust took the view that that wasn't relevant because there wasn't a valid monitoring exercise. However, the figures are there and it's accepted. It would have been a non-compliant result, it's the last sentence of 53, but was not acted on because the exercise was not treated as valid. And then, since the duty return rate was regarded as invalid, because below the threshold, Ms. Atkins of the Trust notified the doctors concerned that the monitoring exercise was deemed invalid on this basis. The doctors were advised that the rota would be remonitored in January 14 with a new cohort of F1 trainees working in general surgery. That was done. The result was valid and compliant. And then the judge's conclusions, which appear later in the judgment, and you see this starting at page 167, paragraph 148. So the round was set up, this is paragraph 151, on the basis of 22 doctors. And then at the very last line of the page, Ms. Atkins accepted that this was a mistake on the part of the defendant, and that the better approach would have been to treat this unassigned slot as not being included in the calculation of expected duties, as Ms. Atkins also accepted the expected duty figure for a 21 doctor shift, that is, taking out the doctor who is on a different type of work, would have been a different figure, different number of duty periods, and so would have been valid. So what the trust did is say, well, we've set this up as a 22-doctor monitoring round. We realise now that one of the doctors that had been included in that round ought not to have been. And therefore, said the trust, what we're going to do is we're going to treat it as an invalid monitoring round because it was not set up properly. And we're going to re-monitor to make sure we get it right. And the trust says that's a perfectly rational step to take. It had been set up wrong. What Dr. Hallett says is, well, what you could have done, because you had all of the various statistics, is you could have worked out what it ought to have been had it been set up in the proper place at the first time. Now, the trust accepts that that could have taken place, but it says that it had a choice. It's perfectly rational for it to say, look, this was set up in the wrong way, it was a pure error on our part, let's start again and make sure we get it right. They did, and they got an outcome. And the trust says,
The
well,
pure error is theirs, but results in an adverse result from the point of view of the doctors.
well, the error was certainly the trust's, and
Why should the doctors pay the price?
I'm not sure that the doctors were particularly paying a price, because the trust position was this was just set up in the wrong way at the beginning. So it could have been, an exercise could have been gone through to reconstruct what ought to have happened with if it had been done in the right place. But we didn't start it in the right way. So we're going to make sure we've got it right, and then they did it and it proved to be compliant. It could equally have established that the round was non-compliant because it was looking at the rota on a 4-month basis. Had it been, it would have been backdated. But
The new one.
the new one, yes.
But my lord says, why was it thought necessary to start again? Because it seems to me it's as if the calculation had been made manually, and the manager making it simply got his sums wrong. But you wouldn't say that it all has to be started again.
It wasn't quite that, and the reason it wasn't is because you'll recall that the trust at any one time is doing 70 or 80 of these monitoring rounds. It starts off with a basic understanding of what all of the rounds are going to be for each of the various rotations that are in place. Now, one individual hadn't appreciated when the monitoring round was set up that one of the doctors on one of these 80 rounds was doing a different type of work because they were retaking. So they couldn't fully participate in the rota as it had been constructed because they were confined to doing day shifts. So at the end of the monitoring process, the realisation is made that it was set up incorrectly because in that particular round, that particular doctor should not have been included. Now, anyone, or Dr. Hallett, is entirely right to say the trust could have gone into that, reassessed it, redone the figures, and done the manual calculation, and worked out, as Dr. Hallett did for the purposes of the trial, that this would have proved to be valid but non-compliant. But the trust position was this was set up in the wrong way, one of 80 that was done. There's clearly a mistake in this. We've put this forward to the next round.
It didn't affect the other 79 groups.
No, not at all.
We're just talking about,
We are.
as it happens,
We
Dr.
are.
Hallett's group.
It is as it happens,
Yeah.
Dr. Hallett's group. It has emerged that this mistake took place. And what the trust did is, well, there's been a mistake in one of these 80 rounds. And I refer to the others simply to give the context of the magnitude of the overall exercise that the trust is engaged in at any one time in trying to do this assessment. It's monitoring 80 rounds and it's looking for each of the features set out in the key principles of the monitoring guidance, whether average hours are right, whether rest breaks are right, whether natural breaks are right. All of that has to be assessed for all of them. And in that context, in the magnitude of the exercise that was being undertaken, the trust said, well, look, what we'll do is we'll re-monitor this at the next available opportunity and make sure we've got it right on that occasion, and then that will give an answer to whether this rota is compliant or not that can be applied prospectively and retrospectively. It had a choice to make, and the choice was...
Wouldn't it just have been simpler just to do it,
I,
rather than go through the whole remonitoring exercise?
I'm not sure that it, well, I'm not sure that it would in the context of doing all of these exercises, because these exercises need to be undertaken. They are regularly undertaken for each of the rotations, and so it was going to take place. So it's just called a remonitoring exercise for the purposes of the existing rotation and for the next rotation. So it's going to take place. It does take place, and it produces a result. The Trust knows that's going to happen. And the decision was taken, well, this was set up in the wrong way, we can remonitor. And the only question is, was that a completely irrational decision to have taken?
Was that the only question?
Yeah.
Two questions, according to the judge. Irrationally in breach of contract.
Sorry, where do you read that?
152, irrationally in breach of contract.
Yes, I understand that to be the same point, that if it is irrational, it's in breach of contract, i.e.
May
it's
it
in,
not be in breach of contract, quite independently.
that's not the way it was put. The way it's put is that it's a perverse exercise of discretion, which is a breach of contract.
Okay.
So that is what this is. Was this a completely left field decision to have taken in the context of the operations of the Trust as a whole? And the judge considered that it was not irrational, and she gives her reason, or she gave her reasons in paragraphs 152. Considers that the the defendant was entitled, as a matter of contract, to adopt a denominator of 218 being shifts expected to be worked by reference to the contracted rota as a whole. Since the purpose of the monitoring exercise was to assess compliance across all expected shifts for that rota, the defendant was entitled, contractually entitled, to conclude that the exercise would be valid only where actual returns were submitted in respect of 75%. Even if that's not right, if the defendant was required to exclude the doctor altogether. The logical consequence is that this monitoring exercise was rendered invalid by reason of the flawed basis on which it was conducted. Or, as Ms. Atkins expressed it when she gave evidence, it was a cancelled or void exercise, i.e. because it had been set up incorrectly, it couldn't be relied upon. I do not consider, continued the judge, that the only option open to the defendant was to treat MR2 as valid in the circumstances by performing an alternative calculation that excluded that doctor after the event. Rather, the defendant was or would have been entitled to conclude that that round was invalid and remonitoring was called for. And I respectfully adopt those reasons.
Was it put to the Trust's witness that you wouldn't have done this if the result had been without, if the flawed result had been 75.17%, you wouldn't have
I'm
done
afraid
this?
I don't recall whether that was put. I mean, to look at another context, which I'm about to, there was no suggestion that this was a deliberate decision by Ms. Atkins or by the Trust. It was simply an error to be seen in the context of the magnitude of the overall exercise. And there's no suggestion that the decision to remonitor was taken in order to avoid that conclusion. That isn't the suggestion that was made. It is that, given what had happened, there was only one step that should have been taken. There's no suggestion of seeking an end. And in relation to, there was another doctor, you'll recall, who completed returns, but because of a technical hitch, she was unable to submit them. And the judge considered that the Trust was entitled to consider that the monitoring round was closed. And I've taken you to that bit of the local arrangements which says that there's a 2-day window after the closure. So in paragraph 154, line 4, the defendant was entitled to treat the round as closed when it did, I'm quite satisfied that neither Ms Atkins nor the defendant were seeking to skew the results by preventing that doctor from submitting monitored data in respect of shifts she worked during that round. The evidence showed that...
Is it that there's no appeal from this paragraph, is there?
Well,
Mr. Kamner's complaint is about Dr. Mohammed, but not about Dr. Clark, I think.
Well, I think this is being used as an illustration of how things go wrong. And I think this was the context in which my learned friend referred to malaise at the end of his submission. But I want to counter that by showing that actually what was going, this is the individual who was dealing with it and who gave evidence. Ms Atkins was entirely prepared to admit late returns when raised with her directly and promptly. She did so when she had no idea what those returns would show. In other words, whether the shifts were compliant with natural breaks or not. So there were other circumstances in which returns were made. She didn't know what they were going to do and she let them in because they'd been raised with her promptly, even though the window had been closed. On that, again, it reinforces the approach that the Trust, through Ms Atkins, was taking to these rounds, which was entirely open, in a way that it intended and thought was to be fair, and in my submission was rational. And in those circumstances, in my submission, it was not irrational for the Trust to declare the round to be invalid, to engage in a re-monitoring exercise which, properly set up, could determine whether the rota was compliant. That took place and it determined that it was indeed compliant. So for all of those reasons, I invite you to dismiss the appeal.
Thank you very much, Mr. Leaper. You've been very patient. Mr. Kamner.
My lords, my lady, what I propose to do, if it's convenient to the court, is start with the points in relation to the contract that my learned friend made this morning. Then I'm going to deal with the more general submissions he made about the purpose of the monitoring and the rationality, monitoring the rota as a whole. And then finally, but only relatively briefly, I'll touch with the maths question that we were set at 1 o'clock. So may I just, in order to answer a question that was raised by the court, hand up 2 other pages of the TCS which aren't currently in the court's bundle?
Yes.
Thank you. I've got 3 sets here and my learned junior will pass them to counsel. I'm afraid we don't have a stapler. They're 2 separate parts of the document, and it's only the first page that I'll take you to at this stage. A question was asked this morning about the legal status of the TCS, and if my lords and my lady will so kind as to look at subparagraphs 1 to 4 of the introduction, you will see that it incorporates in paragraph 1 all the amendments agreed between the Secretary of State and the medical and dental professions, that the remuneration and terms, conditions of service set out in this handbook have been approved by the Secretary of State under Regulations 2 and 3 of the NHS Remuneration and Conditions of Service Regulation 1991 and under paragraph 11 of Schedule 3 to the NHS Act 1977. Through the wonders of the PCS Court Wi-Fi, I've been able to look at the regulations whilst in court. Unfortunately, I haven't been able to produce copies, but may I just read to the court the relevant, very short passages from the regulations. Essentially, such terms and conditions as are agreed between the Secretary of State and the profession's representatives have to be adopted by the trusts. So, Regulation 2, which is headed Remuneration of Officers, says that subject to any directions, remuneration, whether or not paid out of money provided by Parliament, of any officer who belongs to a class of officer in respect of which remuneration has been agreed in negotiations and approved by the Secretary of State shall be the remuneration so agreed and approved. So you're paid what the parties agree you should be paid, and that's 2A. 3A provides that subject to any directions, the conditions of service of an officer who belongs to a class of officer in respect of which conditions of service have been agreed in negotiations and approved by the Secretary of State shall include the conditions so agreed and approved. So once again, a statutory obligation for the contract terms to consist of the terms and conditions of service that are nationally agreed. Paragraph 11 of Schedule 3 to the NHS Act was concerned with something called the Public Health Laboratory Service Board, which no longer exists, and that provision is of no relevance and has been repealed.
Could you send the regulations?
Yes, we will
to
do.
my clerk,
Indeed.
close of play today.
Just for my Lord's notes, it's SI 1991, number 481.
As indeed it says.
Yes, as indeed it says. And subparagraph 3, coming back to the introduction, says that any amendments are incorporated. Subparagraph 4 provides that the approved provisions of this handbook are the terms and conditions of service determined from time to time for the purposes of the contract of hospital, medical and dental staff and others, and have been so determined by the Secretary of State for the purpose of those contracts requiring the Secretary of State's determination. So that's, I hope, assists the court in understanding what the status of the TCS are, and that may well be why it's described in the Trust Monitoring Guide, page 51, as contractual legislation. Or perhaps more strictly accurately, a legislative contract, but one way or another, it explains the combination of those two words. May I move on then to my submissions in reply proper? And may I begin by making 3 short points in relation to paragraph 6A of the F1 contract, which of course is in tab 1 of the supplementary bundle at page 3. And I'm going to draw attention to 3 phrases within the paragraph, beginning with the reference to the contractual obligation to monitor junior doctors' New Deal compliance. My Lord Justice Bean asked the question what that was a reference to, and in our respectful submission, the answer to that is found in first in paragraph 20H of the Terms and Conditions of Service, which you may recall are only to be found, at least that part is only to be found in the judgment, but that is the part of paragraph 20 of the Terms and Conditions of Service, which expressly says that the controls on hours of duty in 22A must be complied with. It's at page 136, paragraph 22 of the judgment. So the compliance, in our respectful submission, is compliance with the New Deal terms, controls on hours of duty, and those controls themselves are set out in paragraphs 22A and particularly 22A Roman 7, which is over the page. Again, there's reference to controls and hours of actual work and rest, and I'll come back to this very briefly, but that's where the reference to the 2 health service circulars are to be found. Then, I'm sorry to jump from file to file, but if one looks at the first health service circular, which is at tab 2 of the supplementary bundle, HSC 1998-240, one sees there, page 20, paragraph 2, that reference is made to the New Deal hours controls as set out at Annex A.
Behind you as usual. Tab 2,
Para 2, page 20. this time the words New Deal and the words hours control are to be found together. The New Deal hours controls are set out at Annex A, and then rest requirements within New Deal working arrangements are in Annex B. And as both my learned friend and I have drawn to the court's attention, on page 24 in Annex A, reference is made in footnote 3 to information on how to calculate and monitor rest periods being contained in Annex B. So in our respectful submission, New Deal compliance is a reference to compliance with the network of rules that is set out in the what we've called the national documents. And indeed, the first paragraph of the monitoring guidance itself, which is on page 42, the beginning of tab 4, says that the New Deal has required since 91 an hours monitoring system capable of recording and checking hours by doctors in training against a set of hours, limits and controls. This was further refined in 1998 under the Health Service Circular we've just looked at, which introduced new guidance and controls on rest periods. So in our respectful submission, coming back to the F1 contract, junior doctors' New Deal compliance is a reference to compliance with those controls you find in the national documents. My second point, a much shorter point, is that if one looks back at the famous clause 6A on page 3 of this bundle, the next few words after contractually obliged to monitor junior doctors' New Deal compliance is a contractual obligation to monitor the application of the banding system. And that again in our system is a reference, as a focus on the national documentation and the national rules. And my third point, and I really won't labour this because I've made it probably too many times already, is that the phrase upon which my learned friend relies, through robust local monitoring arrangements supported by national guidance, is a reference, we respectfully say, to the mechanics, the nuts and bolts. And I dreamt up an analogy, for what it's worth, which is about speed limits. Parliament sets speed limits for driving on the roads. It's for local police forces to decide how many speed cameras to have and where they place them. So that is a good example in our respectful submission of local monitoring arrangements being set by the local police force or the local authority, but it does not detract from the fact that the criteria themselves, the 70 mile an hour speed limit, is one that is set nationally and could not be regarded or described as a local monitoring arrangement, however robust. And two last subsidiary points on this. One is that there is guidance in the true sense about the nuts and bolts in the monitoring guidance itself, for example, paragraphs 28 to 31 at page 47. So there is guidance to help the trust decide how to set about doing the measuring, but that's, we say, a different thing from actually being allowed to set the rules themselves. And finally on this point, that we respectfully submit, and this is a point raised by way of a question by my Lady Justice Nicola Davies, that the reference to robust local monitoring arrangements does not free the trust from a duty to be consistent in the rules that they apply, in the criteria that they set. And just for the court's information, in this contract, as we all have seen already, there is a footnote 4 on page 6 which refers specifically to copies of HSC 2000-031. A footnote 4 is a typo or at least its placing as a typo, because it's actually a reference to accommodation, or refers back to a reference to accommodation. Just for the court's information, where it comes in everybody else's contract, the standard national contract, is at 3E. On page 2. And we say that placing is wholly consistent with what we say is the true position, which is that those documents are incorporated. Though, of course, we respectfully submit that the real source of their incorporation is their reference in parentheses in paragraph 22A of the two TCS themselves.
Yes, so sorry. You say that the document we have at tab 1, which we've called variously the F1 contract or the Derby contract, ought to have the words see also note 4 at the end of paragraph 3.
3E, yes. Footnote 5 rather than footnote 4 for what it's worth, but that's what it refers back to in the standard contract. My next submission relates to the first of the Home Health Service circulars, 98-40, in tab 2 at page 29. This is the table which contains a summary of rest periods. And my learned friend, sorry, I think I've got the wrong reference. There's a reference to rostered that he. Thank you. It's in Annex. Yes, in Annex B. I managed to. Yes.
It's the note on page 29.
Oh, it is. Yeah, I'm sorry, my lady. My lady's ahead of me. Yes, it's the last word on the first line in the passage in italics. And my learned friend places a great deal of reliance on rostered and says that must mean it's the programme of shifts that was built before the particular house or rota even started. But in my respectful submission, that's not what the word rostered would ordinarily be expected to mean. You're normally rostered to do something when you're actually going to be doing it. And this issue, the meaning of the word rostered, was considered by the Employment Tribunal in the Chamberlain case that I mentioned briefly yesterday. And can I just show you what they say? Of course, not for a moment suggesting you're bound by it, but they do refer to the OED definition of the word roster. It's in the authorities bundle at page 28 within its tab 9 and page 28 within the tab. And it's
Speaking for myself, I haven't looked at the tribunal decision at all. One of you told us it was there, but I haven't read it. So what did it decide?
It decided that it was a breach of contract for another trust to do exactly what this trust did. And it was the Allocate software that was under consideration. If one looks at the As my Lord knows, at the start of an employment tribunal judgment, there's a summary of what they decide before they give their reasons. And item 2 of the summary is that, in particular, the trust was not entitled to substitute data for unmonitored periods, including annual leave, sick leave, study leave, and duty periods worked where no data was returned by the doctors. And on page 29 of the judgment, the particular reason I'm drawing it to the court's attention now is paragraph 84. Beginning at 83, there's a reference to the few words we've just been looking at, or at least the word rostered, and it said the concise Oxford Dictionary definition of roster, which gives me as list or plan showing terms of duty or leave for individuals or companies. Tribunal is satisfied that the contract must be referring to what had actually been assigned as a duty period to a particular individual. As the whole purpose is to monitor hours worked, it would otherwise have no meaning. So we respectfully submit that it would be quite wrong to regard the use of the word rostered in Annex B as a clear indication that what the national documentation was focusing upon was not what actually happened, but on the programme for work that was designed before the rota even started.
Thank you.
My only other point on the health service circulars relates to the other one, 2000-031, at page 40 in tab 3. In answer to a question from my Lord Justice Simon, and if I may respectfully say so with perhaps a marked lack of enthusiasm, my learned friend was constrained to accept that on his analysis of the contractual framework, the Trust could, if it wished, have set a threshold of 50% rather than 75%, or indeed 10% or 90%, whatever figure the Trust wished to have. In our respectful submission, that would not be consistent with the spirit or the language of 2000-031, because at the very top of the page, at page 40, under the heading Purpose of the New Contract, it said that the new pay banding system is designed to provide clear incentives to NHS employers to secure compliance with the new deal and reduce hours and intensity in line with the commitment in due course to implement the Working Time Directive. There are no clear incentives for NHS employers if the NHS employer can set the criteria as whatever it feels like setting it as. In reality, of course, nobody suggested that trusts do anything other than use the 75% thresholds. But in our respectful submission, the idea that it's entirely within the discretion of the trust not only to work out the nuts and bolts of how to monitor, but set out what the criteria are, would be wholly consistent with the whole statutory and contractual framework. As regards the monitoring guidance, and I hope the court will appreciate, I'm trying not to simply repeat the points I made yesterday for the sake of it, and that's why I'm darting from point to point. But I'm now going to dart, if I may, to the monitoring guidance itself. My learned friend drew the court's attention to the key principle at the top of page 44, which is that properly resourced locally, with the ultimate contractual responsibility for providing and overseeing monitoring processes resting with NHS trusts and as the employers of junior doctors. And he submitted that that meant it was up to the trusts to set the standards. In our respectful submission, that's not right. All that's doing is recognising that it's for trusts to employ enough doctors and organise its business appropriately to ensure that the right breaks are taken, the right number of hours are worked by doctors, and also that they ensure that the monitoring process, the mechanics, the nuts and bolts, are conducted in a proper and rigorous fashion. My other point, or perhaps two other points on the text of the monitoring guidance relate to paragraphs 26 and 27 on page 47. So my learned friend's submission was that paragraph 26 focuses attention on the whole of the rota, but if one looks at the, and he made the point that I hadn't focused on the first half of the paragraph. May I do so for a moment to draw the court's attention to the fact that on the fourth line of it, the reference is to looking at such data as is available to trust medical staffing sections, for example, weekly shift stroke rota timetables. So it's not asking them to look at the whole timetable from the start of the 22-year period. It's focusing on what's actually happening in the real world.
22 weeks.
22 week. Did I say something else? I do.
You said 22 years. Right.
And again, in our respectful submission, he has no answer, if we may respectfully say so, to the point that the last sentence of paragraph 26 is just wholly inconsistent with the proposition that it's expected working patterns rather than actual working patterns that matter. Finally on this document, as for paragraph 27, and the court has heard too much from me probably about this already, but the passage that is in bold is a reference to 75% of all the duty periods worked over the monitoring period. What that means is that all the duty periods worked over the monitoring period are the 100%. So the total from which you take validity is the duty periods worked over the monitoring period. It just doesn't leave any room to include in the calculation time breaks, duty periods that were never worked for holiday or sickness or anything else. As for the local documents, I'll deal with this very swiftly indeed. Neither of them states on its face, neither of the two that the trust relies on states in its face that it has contractual force, neither states on its face that the thresholds are whatever the trust wishes them to be, which if that were the position, one would expect them to say. In our respectful submission, question 14 in the FAQs, which is at page 59, is an immovable object so far as my learned friend's argument is concerned, because it refers to the 75% duty return rate being required by reference to actual hours worked, not annual leave, study leave, etc. Whereas in fact, the approach that was adopted by the trust does include annual leave for the return. My learned friend drew the court's attention to an exchange in evidence, which is quoted.
If it's not a contractual document, where does that get you?
Nowhere. It's just, and perhaps I can be criticised that this is my learned friend put a forensic point, more accurately a jury point. But my jury point is that even if the local documents are contractual, don't actually establish what the trust says they establish. So that's the relevant reason why they matter.
Well, they establish what you say. The contract
Sorry,
says.
my lord is quite right.
Yeah.
All they do is quite rightly, it's a local document telling you what the national documents say. I was about to move very briefly indeed to the judgment at paragraph 113, which is at page 159 in the bundle. In which Her Ladyship records a question and answer of Ms. Atkins, the Trust's witness. Question was, so far as you were aware, was there a positive decision by Derby to depart from the national guidance and to set up its own rules about monitoring? And her answer was, I think we follow the national guidance but with local arrangements. And in my respectful submission, with great respect to her, the learned judge misinterpreted that answer, because it's plain in our respectful submission that the person charged by the Trust with being responsible for doing this monitoring herself thought that there was no inconsistency between the national guidance and the Trust's application of its criteria. My lords, my lady, my learned friend took 2 pleading points against me somewhat unexpectedly. And may I just make these 2 points about them? The paragraph that he said limited us to express incorporation rather than the alternative of...
Isn't this an argument of law?
Yes. Well, my lord, I won't say any more about it. I'm just amor proprio, perhaps, encouraged on my own and my learned junior's behalf, encouraged me to try and justify the pleading, and I will do, but it's not necessary to do so, so I won't take the court's time.
Pretty depressing if we came all this way with this important test case set up and it was all found to turn on the wording used in paragraph whatever.
Yes. But in our own defence, my lord, we have throughout this case advanced it on the basis of express incorporation or in the alternative incorporation by inference.
Yeah.
So, my lords, my lady, those were my submissions on the contract points. May I come on now to the points that my learned friend has made both yesterday and today, this afternoon and just before the short adjournment, about the purpose of monitoring. And this goes both to the arguments from common sense about which approach is which is the contractually correct approach, but also to the rationality argument, primarily to the rationality argument. My learned friend said, and I noted down his language carefully, that the purpose of monitoring is to monitor the rota as constructed. So he used the qualification as constructed to distinguish what we were saying, which is monitoring the rota as it truly happened. And our response to that is this, that of course, in a general sense, the purpose of monitoring is to monitor the rota. It's to check that people are getting their natural breaks. But to use or to add the phrase checking whether the rota when constructed is compliant is to put a spin, perhaps an unfair word, but is to put a twist on what the purpose of monitoring is, which we say is not justified. And the key, we say, that unlocks the logical error in the Trust's argument is this, that my learned friend said this morning that monitoring is directed to what he referred to as the proper operation of the rota. Not what happened in practice, but the proper operation of the rota, that it was set up correctly. What that means in our submission is that he is contending that the Trust's approach was to check whether the rota was okay on paper, not whether it was functioning, giving the right natural breaks in real life. On his case, if on paper the planned rota should work when it begins, and it should work such that doctors get their natural breaks, then the contractual obligation to provide natural breaks will be complied with. So it's just a planning issue. But there are 3 reasons why I respectfully say that that just can't be right. The first is that the point of all of this is patient safety and doctor welfare. It's not rota design. Secondly, when in August or February, whenever it is, the rota is about to start, there may be a notional set of shifts, but there will be no natural breaks programmed into them, because when the natural breaks are actually taken depends on the pressures of the day and the workload of the doctor. So whereas you can have a pre-planned 10 night shifts this week, 25 day shifts, you will not have a pre-plan for how many natural breaks there will be, and you will certainly not have pre-planning for there to be certain shifts with no natural breaks at all. Because no trust goes into a rota hoping and planning for some shifts without natural breaks. And third, in our respectful submission, if it's all a paper exercise to assess the proper operation of the rota, why bother getting actual duty returns at all? Because the logical consequence of my learned friend's argument is that you know from before the rota begins whether or not it will be compliant.
Well, that's a bit of a parody, isn't it, of Mr. Leeper's argument, because Mr. Leeper accepts if Dr. X is on duty and produces a return saying, I got no natural breaks at all this week, or only on Monday but not on any other day of the week, that is a factor to be taken into account, whatever may have been planned.
Yes, my Lord, yes, I don't want to over-egg my pudding, but it is right, and I noted this down when he said it, that my learned friend said that the purpose was the proper operation of the rota. And he has to say that because his whole case is it's not necessary to look to see what happens in the real world. And I won't bore the court by labouring once again our point that the whole purpose of this is to see what happens in real shifts to real doctors on real days. And my learned friend, when asked a question by my Lord Justice Bean this morning, said that the answer to the real world problems that arise is to sort them out by making changes to the rota and making things compliant. And of course that's what trusts must do. But it doesn't detract from the fact that the TCS provide for a, perhaps incentive is a better word than penalty, but one way or another, a financial G-up to try and encourage trusts to observe their obligations to provide natural breaks.
Well, it is a penalty in some respects.
Yes, it is.
It doesn't reflect the work done by the doctors.
No, it is absolutely so. But it is, the way it's described in the documentation is as a clear financial incentive. It's not, the word financial is not used, a clear incentive. And so the fact that trusts will be motivated to solve the problem in the future doesn't detract from the right to band 3 in the meantime. The other main issue in relation to his arguments of purpose that I wish, my learned friend's arguments of purpose that I wish to address, is the points that he makes about annual leave distorting the results. And my learned friend said, and again, I hate it when counsel do it to me, but I'm about to do it. I'm taking his words from the note that I made. He said that people are deliberately rotated to work longer hours at times because that's necessary to compensate for annual leave. So annual leave gets in the way, makes some people have to work longer and perhaps lose their natural breaks. He said it may create a pinch point and therefore may make it harder to satisfy the national breaks requirement. And our respectful submission, this is wholly misconceived, with great respect to my learned friend. For what it's worth, it was no part of his argument below that the justification for the Trust's approach was to correct distortions from lots of annual leave in the 2-week period. That's why you don't see any reference to it in the judgment. And we have at least his opening and closing submissions. But if I can deal with the point on its substance, it's this. The fact that doctors are bound to take annual leave during the course of their rota does not absolve the Trust from its contractual obligation to ensure that those who are still working in a particular week get their natural breaks to the minimum contractual extent. There is a contractual obligation to design the whole setup so that even taking account of annual leave, there is space for junior doctors to take their natural breaks. And I will, if I may, it's not even an illustration, I hope this is a description of how it is in practice. It's common ground, a 22-week rota, ordinarily 22 doctors on the rota. The contractual leave entitlement is in the doctors' contracts. I showed it to you yesterday, and it's 27 days over the course of a year. That works out, since there are 3 rotations of 4 months each, that's 9 days per doctor per rotation. So 9 times 22 means that there are 198 shifts that will be vacant or will not be worked because of holiday. The word vacant's wrong actually, but they would not be worked because the doctor is on holiday. That is wholly predictable because it's known in advance that no doctor will work all 5 days a week, assuming it is a 5-day week, all 5 days a week for the 22 weeks, because each has contractual entitlement to 9 days holidays. Nothing unexpected about holidays happening.
Well, not happening, but when they happen.
When they, my Lord, may I come on to that? The Trust, therefore, doesn't design the rota on the assumption that every doctor will work 5 days a week for 22 weeks. They design the rota building in a cushion for the fact that doctors take their annual leave. They build in extra capacity. Presumably they don't need to make this point. They also build in a bit extra for sickness. They don't know when it will happen, but somebody will be sick sometime. So, the Trust works out that it needs 22 doctors to fill general surgery F1 at Derby Hospital, making allowance for the fact that each of those 22 will take 9 days holiday at some point in the rotation. And that is...
This may not be essential, but just for the narrative, do the employers have any power to say you can't all go on leave at the same time?
It is. And that's the other page of the document that I handed to you.
Oh, right.
The other page of the TCS. Perhaps we'll deal with that now. How I put it in my script, so to speak, was that there is no possibility that all 22 doctors will decide to go on a coach trip to the Scottish Highlands over the same week. And the Trust has the final say when people take holidays. It's paragraph 215. These are the TCS. It says, practitioners shall notify their employing authority when they wish to take annual leave, and the granting of such leave shall be subject to approved arrangements having been made for their work to be done during their absence. So as one would expect, the whole of the general surgery department is never going to be empty on a particular week because young doctors have to take their holidays. There is a power for the Trust to make sure that it's staggered. And in terms of planning, planning before the rota begins, the way the Trust deals with it is through this concept of prospective cover. My Lord asked arguendo yesterday about the meaning of paragraph 68 of the judgment. Can I show you the court this? Because my submission, this is the explanation. It's at page 149. In the second sentence of paragraph 68, Her Ladyship observes that the rota factors in to the calculation of the number and length of shifts or duties required the fact that doctors will be taking annual leave in the course of the rota because they have an entitlement to it. The rota doesn't allow gaps for annual leave days, but instead calculates the number of hours overall required to enable individuals to take days of annual leave within that period, and those hours are reflected in the contracted rota template once it's constructed. And so what that means in our respectful submission is this, that prospective cover just means that they appoint enough doctors to cope with holidays. They build in enough rotas, enough shifts on the rota, so that general surgery can function, even though some of those shifts won't actually be worked, because the junior doctor is taking her or his holiday. Put another way, and I don't mean this rudely, the total figure of the shifts is inflated because it includes shifts, both shifts that will be worked and shifts that won't be worked because of holidays. So they have a grand total number of shifts which they know will never all be worked. And I'll just give you the mathematics. You've got 22 doctors, assume they have 5 shifts, and it's a 22-week rota. That is 2,420 shifts, although everybody knows that at least 198 of those shifts won't be worked because that's the 9 days holiday times 22.
What was the previous figure?
2420. So the contracted rota template has a total of 2420 shifts on it, even though it's inconceivable that 2420 shifts will actually be worked because of the 9 days holiday that everybody's entitled to. Now, none of that causes a problem for a well-organised trust because they know full well there are going to be holidays and they design their capacity accordingly. So that may be why there are 22 doctors and not 21, for example. But none of this, and this is, I come to the crunch, none of this means that it makes sense to include shifts that are not actually worked because of holidays when calculating validity or when calculating compliance, let alone does it make sense of assuming that if those 198 shifts had been worked, well, not, it wouldn't be, if the 2 weeks worth of holiday shifts had been worked, they would have been compliant. So prospective cover is intended to add duties to a rota which duties were not intended to be worked but are intended to leave space for doctors to take annual leave, to leave a cushion for doctors to take annual leave. So treating those periods which nobody ever thought would actually be worked as having been worked and being compliant is wholly illogical. And then how does that impact on the monitoring round? Annual leave, as I've said, our submission is not an unpredictable fact. It's fully known It's expected to be spread across the 22-week period. That's why trusts have a power to control when it happens. People only actually take leave if there's sufficient cover through those who remain. And that means that it has to be staggered. As I said, you can't have the coach trip or the holiday in Ibiza. So the idea suggested yesterday by Mr. Leaper that you need to add in imaginary duty periods to correct the distortion that otherwise annual leave would have an impact on the monitoring round and would put pressure on the natural breaks of those who remain in the monitoring round and therefore make it unrepresentative, is, we say, completely illogical. Trusts are supposed to organise their functions so that the junior doctors can both take their holidays and those who are still there while others are on holiday, which will always be the case, can get their natural breaks. So the fact that people are taking holidays doesn't, as I've said before, absolve you from taking your natural breaks. And so when my learned friend said, as he did this morning, that if people are on leave, this will lead to non-compliance amongst those who are left, it shouldn't do at all. It's the trust's responsibility to make sure that doctors still have natural breaks. And as regards the question whether, if no adjustment like the trust made is done, that would make the monitoring round unrepresentative, the answer is no, because the safeguard is in the 75% doctor return rate. If by some freak you had half the doctors off on holiday so that poor souls who remain were racing around and couldn't take their natural breaks, then it would be an invalid monitoring round because you wouldn't have your 75% of doctors present. And my learned friend in my submission, and I don't blame him at all for this, but in his answer to the maths question this afternoon, slightly misrepresented the rule in relation to doctor return rate. The doctor return rate, 75% of all the doctors on the rota. It's not 75% of all the doctors who happen to be around. And you can see that from paragraph 27 of the monitoring guidance, which is at page 47 in the supplementary bundle. Under this national framework, at a minimum return rate for monitoring data should be set at 75% of all doctors in training in each rota or shift participating in the monitoring round. That's page 47, para 27. So the risk of a wholly unrepresentative period because too many people are on holiday is avoided by the doctor return rate.
Participating goes with rota, not with
That's my
doctors.
submission.
Right.
And the risk of anomalous results because of everybody wanting to go to the Cricket World Cup is further reduced by the fact that it's the trust that gets to pick the monitoring weeks. And they are exhorted to make them representative. So again in the monitoring guidance at paragraph 20, it said that non-typical periods should be avoided, such as change of house, bank holidays. Now, bank holidays would be when too many people are on holiday. Bank holidays, examination periods, when too many junior doctors would be off doing their exams. And the same is said, for what it's worth, in the local monitoring guidance. I won't take you to it, but at page 51. So there is plenty of protection for trusts to ensure that the monitoring round they actually use is one that is adequately sufficiently representative for the 75% validity thresholds, and therefore that the results that are produced by looking at what the actual returns say is a valid result.
So, Mr. Kavanagh, taking that just one other step, so that cushion of 25%, are you saying that is the unexpected? We've got 75%, all right?
Yes.
And there is a cushion, if you allow me to use that word, of 25%. You are saying doctors on annual leave, entirely predictable. The trust can work out when they're going to go, and moreover, the trust have to identify the monitoring periods. So are you saying of that 25%, that really is to deal with unexpected events or something of that nature?
My lady, yes. I think if I understand, you're asking me about the 75% in the validity rather than the compliance.
Exactly
yes.
that.
Yes.
That's it.
And sickness, study
Sickness, or compassionate leave, or something of that
leave.
sort.
Or study leave, all this problem that I averted to yesterday but haven't emphasised, which is that although there is a rota going over 22 weeks, it doesn't mean there are exactly the right number of shifts in the type of the various subdivisions of types in any 2-week period.
Yeah.
So it's to deal with complications such as that.
But it's both the expected and the unexpected, isn't it? I mean, as you rightly say, the leave, at least viewing the 4-month period as a whole, it is known that 198 shifts will be taken as leave. But you're saying that the doctor return rate is 75% of all those on the rota.
Yes, that's my understanding.
And the 25% takes care of both the predictable absences on annual leave and the unpredictable absences of people who are sick.
Yes, I see that I'm in the embarrassing position, having agreed with my lady and now agreeing with my lord when he puts the opposite question to me. But
Well,
yes,
I don't think they were incompatible. At some point, if you're going to give the answer to my maths homework, as Mr. Leaper described it, you may be able to show it in practice.
yes, certainly. And I'm going to offer to do that in writing for a reason I'll come on to in a moment, if I may. Yes, it's just pointed out to me that I should emphasise that it's the doctor return rate that takes everybody. It's the duty return rate is only those who are actually there, not on leave.
Oh, right.
So, just to conclude on this point, we respectfully submit that it is no explanation for taking account of artificial and misleading data, that if you don't do that, holidays are going to distort the results that you get. Just a couple of final points, if I may. One is that my learned friend makes the point, and he's right, of course, that the use of monitoring rounds is an inexact science. You can't guarantee that it will be truly representative, and in a perfectionist world, you might obtain returns for every single shift over the whole 22 weeks and perhaps have some power of compulsion to force every doctor to provide a return. But that's not an issue in these proceedings. The Trust accepts that the snapshot of a monitoring round is the process that's to be followed, and indeed they themselves calculate the results to 2 decimal places. That's not under challenge. And so, in our respect for submission, the suggest that something else needs to be done to test the rota as a whole is just not right. You test the rota as a whole by looking at the results of the monitoring period. 2 very brief points, and then I'll come on to the figures. my learned friend made the point that it can't be irrational because lots of trusts do it. Although lots of trusts do it, there's actually one software program. It's the default of one software program. So it's lots of trusts doing it for the same reason. Not in our submission, and that's in any of the...
Move on to rationality.
Yes, although in my submission, everything I've said in the last 15 or 20 minutes is pertinent to rationality. Because it...
Specifically rationality.
Yes. And that's all I was going to say on rationality specifically. I made perhaps 2 long submissions on that yesterday. Dr. Mohammed is in our respectful submission, or his case, is an egregious example of the problem of relying on a proposed rota rather than actual rota. But I won't repeat my submissions on his case beyond that. The question, the test that we were set, if I may put it that way, by my Lord Justice Bean, just before the short adjournment, we have a 2 and a bit page detailed answer to it. But may I summarise it in the following way, that a complicating factor with the test is that the questions that we were asked, although it said that 7 doctors returned some shifts compliant and other shifts not compliant, didn't say how many were compliant and were non-compliant. In fact, on our calculations, whether you use the BMA's approach or the Trust's approach, if you assume, as my Lord Justice David Bean said after the short adjournment, if you assume that those in that category were compliant half the time, the mathematics leads to the conclusion that it's compliant either way. It's compliant if you apply the BMA's approach, it's compliant if you apply our approach. If, on the other hand, you took the figure of 25 of the 70 shifts concerned being compliant, then it would be compliant on the Trust's approach, but non-compliant on our approach. And in those circumstances, I thought rather than take the court through a detailed and convoluted explanation where I would only be about a heartbeat ahead of the court in understanding what I was saying, it might be more convenient if we reduced to writing the explanation and forwarded it to my Lord's Clerk.
If you could each do that, Mr. Leeper wanted to do it. I hope it's not unreasonable to ask that the exam paper was, as Mr. Leeper accepted, to look at each of the 3 tests. You've been focusing on compliance.
Yes.
Is the doctor return rate satisfied? Is the duty return rate satisfied? Is the compliance test satisfied? And don't, as it were, say if the answer to question 1 is no, that's the end of it, because it's helpful to us, not that this is, speaking for myself anyway, it's helpful to see how each of the 3 tests operates with a worked example. So the compliance would be, supposing you've got this far, would it be compliant? Does that make sense?
It does indeed. May I tell the court now that our calculations are that it's both the doctor return rate is compliant, we agree, although our sums are slightly different. I'm just going to check. As far as validity is concerned, on the assumption that they're working 5 shifts a week, which is the basis upon which we've done our sums, it's valid on the BMA's approach, it's invalid on the Trust's approach.
Well, so the sooner we could have these 2 documents, the better.
Yes, so we'll undertake to do it. My Lords, we will promise it, my Lady, we'll promise it for tomorrow from our side.
Is that all right, Mr.
Yes,
Leeper?
Of course.
Good.
And what we'll do, if we may, is do the example both on the basis of 50% compliance, for those where some were compliant and some were not, but also on the figure that 25 were compliant, just to show an example where it makes a difference in terms of compliance. May I just on my back?
Yes.
Thank you. My lords, my lady, just a small detail, but what we would say is a correction or clarification to something my learned friend said. We've been dealing with monitoring round 1 and monitoring round 2. There was a monitoring round 3, which was not part of the pleaded proceedings. My learned friend said that if the Mohammed problem hadn't been dealt with, as it wasn't, and they just waited for monitoring round 3, monitoring round 3 was compliant. Well, it is if you apply the trust test, it's not if you apply our test, but it perhaps doesn't lead very far. So apart from that, unless I can assist the court further, those are my submissions in reply.
Thank you all very much, including the support teams behind you. We're very grateful to both of you. We are, of course, reserving judgment. We'll send it out in the usual way. We're all familiar, and there'll be no need for anybody to attend on the handout. I hope all ancillary matters can be dealt with in writing, and we'll let you have our thoughts as soon as we can. And if you could please send in the answers to the maths homework, but do please exchange them before you send them in to us, because it would be very dull to have submissions saying that so and so's calculation is wrong. But it would be very helpful to know what each of you say as to whether on the trust case each of the 3 tests is passed or failed. Likewise on the claimant's case, and if you want to put in a variation about the doctors who report that they didn't get all the rest breaks, then do. Thank you very much.
All rise.
Shall I tell the clerks to come and collect your files as well as mine?
Yes, and my bag, is all right?
Yeah.
We'll need class and address as well.
Oh, hi, it's John Cavanagh here. Can I speak to
Hold
one
on,
of the
I was
clerks?
just taking over from Sharon. Yeah, he's got a couple of hours, yeah. Oh, actually, no, he's took his stuff.
John.
Yeah, okay then, bye.
Oh, hi there. Just to say, we finished in court, and could somebody come and get my black stowaway and my robes, and Adrian's bag, and also the box from Richard's solicitor, which will be on the second row. Brilliant. So may I just check if Richard, no, Richard doesn't have anything. Yep, that's it. Lovely. Thanks very much. Bye.
Thanks very much, John.
Okay, thanks. Oh. Actually, turn it off, Sharon. I'm sorry. Couple of minutes, 35.